Victor, can you speak more on your motion to, what was that motion?
I can't. I'll have to flesh it out for the court. I don't want to preview it at this point in time. I have to flesh it out and do the research on it, but it would be a motion to amend down.
Amend down? Is it because we're seeing difficulty in convicting him for the aggravated murder?
It's more of a procedural move.
Or procedure, but the court confirmed that they'll have to address Mr. Vanderbilt's motion first?
Yes, that's what the court said.
Is this unprecedented, 2 mistrials?
No, not to my awareness. Mistrials happen quite frequently. I don't know about in Guam, but as far as the U.S. judicial system, no, 2 mistrials is not unprecedented.
Could be tried a 3rd time?
It could be, yes.
Thank you so much. I'm sorry, could you? Mr. Vanderbilt?
Yes.
Are you able to talk more about what happened today? A mistrial was declared, though.
Mistrial by the court having discharged the jury on Monday occurred. So I think all the court did was reflect that had occurred on Monday. So now there is a motion for judgment of acquittal. She wants briefing in compliance with the local rules, and then she'll set hearing dates for that, as well as for a hearing for release of Mr. Agababa.
What could happen next? Could this be tried a 3rd time?
Well, it depends on how she rules on the motion for judgment of acquittal.
Have you ever seen this on Guam?
A 3rd retrial? No, I haven't seen a 3rd trial of anybody historically on Guam. But does that mean the AG's office won't continue to pursue the case? That's a decision that they're going to have to make.
Well, the court agreed that they had to act on your motion for acquittal first. What are your thoughts on the lesser included, the government's motion for a downgrade on the charge?
Well, they're not actually making a motion for a downgrade on the charge. They're making a motion to add to the indictment a charge which they never presented to the grand jury. And even though it is considered a lesser included offense, it is not part of what they provided to the grand jury. And then, we have this dispute about there are 2 different ways in which they claim that the homicide occurred. One is that they claim that it occurred as a result of infliction of physical force to the right portion of the forehead of Shelley, and the other is that this novel theory that came up in the retrial, which was that the multiple patches that she had on her body were as a result of them being placed there by Allan. There's just not even a remote amount of evidence to support that. I mean, it's just without any evidentiary support whatsoever. Dr. Espinola, there could be now an issue about whether or not the government has lost and destroyed evidence, because Dr. Espinola testified that there were numerous patches that were found in the bedding. There's not a single picture of the numerous patches. There's no record of how many patches were attached to her that may have fallen onto the bed. There's just no way of being able to determine the extent to which her cessation of her respiration and her heartbeat may have been as a result of the fentanyl overdose. And so there may be a motion to dismiss based upon government having improperly handled evidence in this case, in the event that the judgment for acquittal isn't granted. But we're going to take this one step at a time, and the next step will be to submit the motion for judgment of acquittal and the motion for release.
You talked briefly about finances. In the event that your judgment for acquittal is not granted, could Mr. Agababa afford a 3rd trial?
No, he couldn't. He barely could hire the expert for the 2nd trial. As everyone is aware, that's something that just occurred prior to Dr. Cohn testifying. The court was unwilling to authorize payment of the money necessary to hire an expert on his behalf, and the manner by which the court recommended that the testimony could be taken was not consistent with what the government argued about. They sought to try to prevent Dr. Cohen's testimony from being audio replayed. So, you know, he's clearly at a disadvantage, and the court system is not designed to pay for, realistically, Guam rules are not designed, and the court system isn't designed to make an honest effort at trying to provide expert services to defendants.
So Mr. Agababa's father was the one that paid for the outstanding balance for Mr. Cohen?
He paid for the outstanding balance to Dr. Cohen and then paid for Dr. Cohen's testimony for the retrial. And if there is a second retrial, he is so financially exhausted he can't afford to pay for it. Allan has had the benefit of family who have supported him with financing for private counsel through the first and the second trial, but they are financially exhausted, and you know, he's going to end up with a public defender who's going to give less zealous representation. I think that's very much a concern, and why it is that due process should not allow for the occurrence of a third trial.
So you don't think you'd be representing him should a third trial happen?
At this point, you know, you're asking questions, we're jumping too far down the line for me to be able to answer. Right now, I'm saying that financially he has no indication of the ability to continue to employ private counsel.